Hi, welcome to this presentation, which has been prepared on the direction of the Immigration Advice Authority. This presentation is about student visas and in particular about the transitional arrangements that currently operate with regard to dependents of students. My name is David Jones. I'm a barrister at Garden Court Chambers and also a director of HJT Training who've been commissioned by the IAA to prepare these videos. At the outset, just to explain that watching this video doesn't enable you to undertake work above your current accreditation level. If you wish to accredit at a higher level, then go to the IAA website. You can find all the information you need to do that from the site. Okay, so without further ado, we're going to first take a step through the general validity, eligibility, and suitability requirements that apply to students and look at the main categories of category application for students, look at some of the pitfalls associated with student applications before looking finally at particular working conditions, switching, and dependent routes, the transitional arrangements. So the legal framework, first of all. So the student visa route is currently governed by Appendix Student, the immigration rules. That came into force in October 2020. And the rules, as you'll know, are administered by the UKVI. They're subject to a pretty constant revision. So this training course will be prepared in March 2026. And it's going to be important for you to scrutinize carefully the rules as at the date that you're giving advice or making an application or preparing an appeal. And so this is hopefully a useful overview on how the student arrangements work, but it's not a substitute for conducting, obviously, careful and current analysis of the law at the point that you are extending assistance as a registered advisor. Okay, so the validity requirements at the core, pretty straightforward, really. When making an application, it's imperative that the application is made validly. That requires you to complete the requisite application form, to pay the required fee, and fees are constantly changing. Indeed, a current fee uplift for students is projected to be implemented on the 8th of April of this year from £524 to £558. And so you're going to need to check what the fee arrangements are at the time that you're making the application. There are immigration health surcharge requirements. The current rate, as at the time that this video is prepared, was £776 per year. Again, that is subject to pretty regular changes, typically in April and then again in September or October. So you have to, again, keep abreast of those changes so that you can properly advise your clients when you take initial instructions and give initial advice as to what the costs are going to be for their application. And then the final validity requirement is the provision of suitable and valid biometric and identity documentation. Vital, as I said at the start, that the application is made validly. An invalid application will basically lead to the application being dispensed with and may have the effect for a person who's lawfully present in the UK but whose leave has lapsed while an application is pending, of rendering them an overstay. Eligibility requirements for students at a glance. The student must satisfy a points-based arrangement, have to accumulate 70 points by reference to 3 subcategories. The first 50 points are fixed on the provision of a CAS, a CAS, from a licensed sponsor. So that's an educational establishment which is licensed by the Home Office to sponsor students. And the sponsoring agency essentially fulfills the core evaluative exercise with regard to the competence and capacity of a student to undertake the course which they're applying for. But that evaluation can be subject to a kind of review by the Home Office in due course, although it's not typically done so, particularly not for reputable and established sponsor organisations. Although, as we'll see when we look at the recent changes to the immigration rules, the Home Office is becoming more vigorous in its scrutiny of licensed providers. The second 10 points, the next 10 points rather, is for English proficiency, and we'll look in a moment at what the proficiency levels are. They vary depending on the nature of the study. And finally, there are 10 points allocated for financial maintenance. Typically, the financial maintenance requirements, particularly for initial admissions, are pretty exacting. And we're going to look at those when we look at the eligibility criteria. So all points mandatory, don't get 70 points, you don't get a visa. So eligibility language requirements, first of all. Proficiency in language is becoming an imperative across a whole range of application processes, and has recently been elevated significantly with regard to settlement. Typically, the arrangements that operate for those applying for courses at RQF level 3 and above are between CEFR level B1 and B2. So there are certain exceptions, however, with regard to those who come from majority English-speaking countries, or those who have a previous degree which is taught in English. You may be able to exempt your clients from it. So you need to obviously engage with your clients' educational background, which inevitably you will be doing anyway, in order to ascertain their competence to undertake the course that they are looking to pursue, as will the education provider have done. But scrutinise their educational history, scrutinise their background, nationality, and look at the immigration rules to see which countries are accepted from the language requirements. Then the financial maintenance requirements, as I mentioned, they're fairly exacting, and so it's necessary to produce evidence of sufficient funds for a consecutive 28-day period ending no later than 31 days before the date of application. The funds must be in the applicant's own name or in the name of their parent or legal guardian. With regard to the level of funding required, just to give an illustration, by reference to a London institution for a higher education course, you'll have to prove possession of course fees and payment of course fees, plus an additional £1,334 per month of the course up to a maximum of 9 months, and that's to cover living costs. And so for a 12-month course, where the course fees are £10,000, that in combination with living costs mean that the minimum fund requirement for an individual looking to study in London will be £22,006, which is a pretty substantial amount of money. Obviously, as it's indicated here, the level rate modifies slightly when you're outside of London because the living costs are deemed to be slightly lower. And there's also a partial waiver facility for those who have previously been admitted as students, or those who are on a scholarship arrangement. They may be accepted from this level of funding requirement or evidence, either partially or wholly. Suitability requirements, these are pretty consistent across the rules. We now have a part suitability, which governs most categories. We have other aspects of the rules, such as Appendix FM, which has its own suitability criteria. But the consistent pattern essentially is that there'll be mandatory refusal to either admit or to extend in instances where a person presents with a deportation order or whose presence in the UK is deemed not to be conducive to public good. And that's in particular in the context of those who receive custodial sentences of 12 months or more, which indeed can lead to a permanent barrier to settlement, but also a very long-term barrier to admission or residence. There's also discretionary arrangements for exclusion based or denial of a visa based on conduct, which falls below the threshold of, for example, 12-month custodial sentence into non-custodial sentences. And it will be a review of the character and conduct of the individual and the nature of the particular offending act. But that discretionary exclusion is not confined to criminality. It can extend to litigation debt or NHS charges that have been unpaid or civil penalties. So again, a detailed review of the client's background circumstances and clear instructions about any adverse financial or criminal conduct will have to be undertaken in order to ensure that the suitability requirements are met. Failure to meet the suitability requirements, a discretionary or mandatory refusal is essentially a complete barrier to progression of an application. It is feasible, even in the context of mandatory grounds for refusal, to seek the exercise of the residual discretion under Section 3 of the Immigration Act 1971, that it's imperative to specifically request that discretion be exercised in an application in supporting representations, absent which the Home Office will not engage with the facility to use discretion. That discretion persists even where the rules frame a ground for refusal as mandatory. And then finally, the last thing to look at is, in addition to sort of character conduct issues, a break in lawful immigration status can operate as a barrier to the extension of a visa as well. If a person falls into status of overstaying, particularly where that extends beyond 14 days. Making applications in time, very important. That will lead to the acquisition of Section 3C leave under the 71 Act, and will essentially allow the persistence of lawful residence while applications are being considered. Fall outside of that section's valid application process, make an application once leave has lapsed, Section 3C doesn't operate. Okay, types of student visa, deal with this pretty promptly, and you'll have access to all of these slides in due course, so you can spend more time reviewing them for yourselves. But there are several distinct categories of student. Look at those briefly. Student visa is the main route for student applicants over the age of 16. You then have child student visas for those between 4 and 17. And then you have short-term study visas, which are for short courses, up to 6 months or potentially up to 11 months for English language courses. And that visa application process doesn't require a CAS. The genuine student requirements is pretty essentially the point at which many student applications can struggle, in particular around academic capability and credibility and course appropriateness. And it's going to be necessary to demonstrate that the person has the preceding academic acumen to undertake the course of study that they're applying to enter onto. And also that the course of study is progressive in the sense and referable back to other courses of equivalent study that have been undertaken in the past. So there's a pattern of learning, doing a degree and then seeking to revert back to a lesser form of qualification is likely to lead to skepticism about the appropriateness of the course and then potentially to refusal. The Home Office can, even when CASs have been issued by education providers, conduct credibility interviews if they have concerns about educational acumen. And it's important to advise your clients of that possibility. They take that course in particular with regard to nationalities where they perceive there is perhaps a high risk of persons not acting consistently with their visa conditions. And you may be aware, but recently, as this month, March 2026, the Home Office implemented effectively a barrier to applications for students from certain jurisdictions, including Afghanistan, for instance, because of the perception that there was misuse of the visa arrangements. And then just a little bit of detail about what to advise your clients to expect in instances where these interview credibility assessments are conducted, and you can consider those for yourself. So the sponsorship arrangements, this is really the crux, the core of the student application process now. As we mentioned right at the beginning, that 50 points are allocated on the basis of presentation with a valid CAS. So entry to the UK as a student is predicated upon students having been sponsored by a licensed UK sponsor. We're going to look very briefly at the categories and the content of the CAS. With regard to categories of educational institution, just a few outlined here: higher education providers, HEPs, with a good track record. These are sponsoring organisations for further education, universities and so forth. Then you have publicly funded institutions, which are locally authority maintained schools and sixth form colleges, which can hold licenses for specific purposes. and then independent schools or private schools where child student visa applications can be made through. Schools holding child student sponsor licenses are eligible to sponsor children in. These schools are subject to the same standards of inspection under the Independent Schools Inspectorate Ofsted as our state schools. Importantly, it is important to ensure that you support and advise your clients to endeavour to secure sponsorship from an established education provider, one with a track record, because there are stringent prescriptive processes that sponsors have to adhere to with regard to record keeping, cooperation with the UKVI for compliance visits, notifying the UKVI of changes of circumstances. And for providers that don't meet those stringent requirements, their licenses can be either suspended or revoked. And either course has profound consequences for the students. The revocation of a sponsorship license basically will throw a student into a situation where they're at best given a finite amount of time, usually 60 days, within which to try and find an alternate provider. And so it's important to guide applicants on reputable educational establishments to apply to, as well as simply enabling them to process an application. Okay, so the CAS itself, the Confirmation of Acceptance for Studies, it's a unique document. It's very important to scrutinise the content of that document before presenting an application. It has a fixed validity period. So looking at the points one by one, the CAS validity period is valid for 6 months from the date of assignment. An application must be submitted within the window of that 6-month window. If it expires before the application goes in, you're going to need to get another CAS. As to the course start date, the CAS must contain the correct start date. Applications from outside the UK can be submitted no more than 6 months before the course start date, and in country no more than 3 months before. And timing errors can lead to rejection. As to the CAS information, number 3, CASs must specify the course title, level and duration, and the total fees payable, any fees already paid, and the sponsor's license number, and confirmation of any conditions attached. And it's important that you cross-reference the information on the CAS with information on offer letters, for example, before making submissions. And finally, number 4, unused CASs. CASs can only be used once. Once a CAS has been submitted on an application, the term used here is consumed, regardless of whether the application is successful. So where there's a refusal and a new application is made, you need a new CAS. Okay, so common pitfalls, just a very quick whistle-stop guide through the kind of things that can cause issues with student visas. I'm not going to, again, dwell on this at length, but it's a resource for you to review in your own time. But very quickly, stepping through the first slide. Pitfalls are often associated with documentation and financial issues, so miscalculations about maintenance requirements or out-of-date financial information, remembering the 31-day cutoff, the information dated requirements. Also, the specification as to the source of funding, and so it's important to ensure that the funds originate from a source which is accepted under Appendix Student. And then finally, language requirement tests which are not eligible or compatible with the self-testing arrangements. Those are common areas where issues can present. And really it comes down to careful and anxious scrutiny of the application and evidence before it's presented to avoid these sort of pitfalls, and potentially pausing the application, initial application certainly, in order to enable the acquisition of all of the relevant evidence. And then just procedural and strategic issues that can confront. Occasionally, CASs can be submitted when they're not active or outside the permissible window of application, so the 6 month for outside the UK, 3 months within the UK. Those are wholly avoidable problems, and it's about taking care to make sure that the application date marries up with the information on the CAS and the framework of the CAS. Another more common pitfall, which is not exclusive to student applications, is failing to disclose previous applications in whatever category where there's been a denial of admission to the UK. Absolutely imperative to give an accurate history. Some clients may perceive that doing so will prejudice their application, but to fail to do so will prejudice their opportunity to come to the UK, not just on the application you're assisting them with, but prospectively, potentially up to 10 years, because a failure to make full disclosure will lead to a 10-year ban. And then finally, incorrect statements, personal statements, in particular with regard to academic kind of capabilities. And again, it's going to be important to check your client's CV, if you like, against reliable background evidence supporting their claimed accomplishments, such as degree certificates, diplomas, and so forth. Original documents will ideally be required. Okay, so we're going to look next at changes that have been implemented, in particular with regard to the admission of student dependents across 2025 and 2026 in particular. And so just stepping on from the general descriptive slide into the actual criteria, new rules implemented commencing in January 2024, which have significantly curtailed the ability of student visa holders to bring dependents to the UK. These restrictions have been extended and developed through 2025. And the object of them is to reduce net migration, essentially. And they have had that consequence in the sense that there are fewer dependents coming, but statistics suggest also that the number of student applications by international students have also dropped, not insignificantly, as a result of this implementation. So the general rules as they are presently with regard to admission of dependents of students, for postgraduate research programs, so this is sort of PhD level, and programs which are funded by the Research Council funding institutions. These are exempted from the restrictions on dependence rules, and so students at that level can still sponsor in their spouses, civil partners, and children, and there's no current indication that those arrangements are going to change. For all other students, this is the bottom box on that same column. Since January 2024, students on all other courses, including taught postgraduate courses such as LLMs and MBAs and MSCs, and undergraduate programs, are no longer permitted to bring dependent partners or children to the UK on the student rule, which is a really quite profound revision and restriction on the arrangements that existed previously. There is an exception for, this is over to the second column, under the heading Government Scholarship Students. There's an exception for students sponsored under government scholarship or sponsorship programs that expressly covers dependents, and where that status is confirmed in the CAS and accompanying sponsorship letter. So it's important to look at the background and origin of the study arrangements in order to ascertain whether there might be an exemption for family members. There are also transitional arrangements for pre-existing students at the point when these changes were implemented. And so a dependent who was present when the restrictions were introduced and held leave as a dependent at that time will continue to enjoy the benefit of dependent status for the duration of their leave, in line with the student principle. So the key transitional provisions, just a kind of useful illustrative indication of where things are. So pre-January 2024, students who received their first student visa for a qualifying course before the 1st of January 2024 could bring their dependents, that's spouses, partners, and children, minor children, where the course was at degree level or above at a recognised HEP. Post-January 2024, with the policy change, new applications for student visas from this time are subject to restrictions and dependent rules. Students already in the UK with valid leave before that point are protected under transitional arrangements, however. And then importantly, number 3, extensions and course changes. Where a student, a pre-January 2024 student who was enabled to bring their dependents in, where that student is changing their course, even if it's at the same sponsoring academic institution, so that a new CAS is required, then a new application is assessed under the rules in force at the time that that application is being processed. And the consequence there is that the transitional protections for dependents do not carry forward. And this is quite a critical point because it has led to difficulties. And so the shifting of studies for pre-existing students, even those with leave before January 2024, can have consequences for the entitlement of dependents to remain. And then finally, under number 4, 2025-2026 consolidation, further guidance is issued in 2025 consolidating transitional provisions and clarifying that all applications, including in-country extensions, submitted on or after the 1st of January 2024 are subject to the new dependent rules. And so that only research programs and government scholarship exemptions being accepted, there is, other than PhD at MSE level, no facility ordinarily to bring in dependents. And in addition to that very significant restriction on being able to bring dependents in with you as a student, there are a variety of other revisions to student arrangements. I mentioned, just looking at the second column, the increase in compliance audits by the UKVI. So there is greater scrutiny now of academic institutions who have sponsorship licenses. And so that just takes us back to the observation I made before about how important it is to coordinate and connect your clients with trusted education providers with a good track record of compliance. Going back to the first column, increased English language requirements, just you can see there that there's been an elevation in expectations with regard to language requirements and a consideration of the ramping up of the CEFR levels. And then under that, expansion of the ATAS requirement has been expanded to cover additional course subjects, which is beneficial. So some positives, some negatives. One last point to highlight is, as I mentioned again earlier on, keep an eye on the surcharge, immigration health surcharge levels, because they are also increasing. And it's going to be important for your clients to appreciate what the costs associated with the application are. I mean, the education costs to come in to study in the UK are pretty profound, but the application costs themselves just to make a visa application and then pay the surcharge are themselves not insignificant. And so that whole panoply of costs, student fees, maintenance costs, application fee, and the IHS surcharge must all be communicated so that a student can organise their financial affairs effectively to enable a valid and successful application at first go. All right, and then the next section we're going to look at briefly is what are students entitled to do in the UK, obviously other than pursue the course of study that they've been admitted to undertake. And so we're going to just quickly scrutinise permitted and excluded activities. For a degree level and above, students at that level, it is possible to undertake employed work up to a maximum of 20 hours a week. But that is a maximum, regardless of one working for a variety of different employers. That doesn't enable the 20 hours to be extended to each individual employer. It's a total amount. For below degree level, it's a maximum of 10 hours per week. And then for foundation and pre-sessional courses, again, up to 10 hours a week. For short courses, incidentally, there's no entitlement to undertake work at all. And then other kinds of activities, self-employment and business activities is not permitted. With regard to work as an entertainer or a sports person, the students may not undertake that kind of work, although working as an amateur or participating in events connected with the student's course is permissible, but commercial engagement is not. Working more than permitted hours will be considered to be a breach of conditions of leave and may lead to cancellation of a visa. And working in a permanent position is obviously wholly inconsistent with working. I should just mention that some voluntary work is entitled. Students are able to undertake voluntary work, provided that voluntary work doesn't take away paid employment from a settled person. Switching routes from student visas, just a very quick overview really, that there is facility for students to switch into other categories, assuming they have successfully concluded their student, their course of study in which they've been admitted as a student, and just an illustration of the different categories that it's possible to switch into. And that includes, importantly, perhaps the family route, so that those who are here for an extended period who have developed a private life, which then transforms into a family life, have that opportunity to switch into that alternate category. And importantly, these categories of application a number of them do admit of settlement in due course. And then just to assist you really, with future applications, it's not something that we need to go through, but just a little checklist of kind of good practice, things to check off as you go through applications, looking at validity, eligibility, the CAS, suitability requirements, and going on then to look at the individual kind of genuine student assessment process and the documentation that would be required to be admitted. Just be aware this is guidance, it's not a template against which you can confidently conclude that any application you make is going to be successful or valid even by following it, but it is a useful outline against which you can then apply your own knowledge, your own research, and your own exploration of the client's circumstances in order to best advance their situation. So I think that's all that we're going to cover today on the student application process. I hope that's been of assistance to you. Just to reiterate, as I said at the start of the presentation, watching this course, reading the notes, doesn't enable you to undertake work at a level above that which you're accredited for, but it hopefully will enable you to more confidently represent your clients and encourage you, if you're not yet at level 3, to consider upgrading. Thank you for listening.